Hi, this is now the second part of lecture 10. Just always keeping in mind that the question, and I would like at the end of this lecture to let me know what you think, of course. Does really advertisement or advertising mold or reflect the value society? The question always comes, the egg came before the chicken or the chicken before the egg. So this is what comes first, the advertising, and then we copy the advertising, or is it something that because of society already having that need that the advertising just molds that or reflects that? Part two of these three sections is the function of advertising, providing information or persuasion. And this is what the court will decide. And it's very interesting because the Federal Trade Commission is to protect society at large. Remember, this is an act. This is a statutory law. And the Constitution protects you, the individual, against government. And statutory law protects society at large. So here is the Federal Trade Commission, that their purpose is to protect society at large, that the advertising does not harm the reasonable people, and it's very important to protect the consumer, and that's us. So the Federal Trade Commission carries out the broadly state goal of preventing unfair and deceptive trade practices, and they are the one that have the authority to do that. And here is business that are protected under the Constitution, freedom of speech. And the Federal Trade Commission says, no, I don't think you should go that way because it's deceptive, it's unfair, it's not treating everybody equal. So we're going to talk about unfair and deceptive advertising. Advertising will be deemed deceptive if a consumer would be misled by the advertising claim. If there is any appearance that there might be some consumer that might misunderstand the advertisement. Vague generalities and obvious exaggeration are permissible because that is puffing, that is not advertising. So what really the logic or the legal reasoning behind this is as long as it's in my opinion, like especially if you go and buy a used car and the used car dealer will say, in my opinion, my mother-in-law has bought this car and it's great. But again, that is his opinion. It's not something that is informative. So if the advertisement is informative, then it's more freedom of speech. But if the advertising is misleading and gives any problem that somebody might buy it and then cause problem, then the FTC comes in. When a claim takes on the appearance of little authenticity, it may create problem. So if I advertise that advertising is real or looks real, or I perceive it as real, that's when the problem arises. Advertising that would appear to be based on factual evidence, but that in fact is scientifically untrue, may also be deemed deceptive. A classic example, advertising occurred when the makers of a skin cream claimed that their product could restore youthful qualities to aged skin. And you know how we value young people or youth. An advertising practice that has been attacked by the FTC as deceptive involved misleading price claims. Advertising to sell 2 cans of paint for the price of 1, for example, and then setting a very high unit price has been held to be deceptive. When you have, and there's been situation where even they give you coupons because if you buy a certain product, it will be on sale the special day. And of course, when you go to the store, the product is not there. And now it's mandatory by law that they have to give you for the next time when more products comes in so that you can still buy it at a lower price. The FTC also regulates advertising that contains the endorsement of celebrities. An advertisement may be deemed deceptive if the celebrity actually makes no use of the product. So whenever you see an actor or somebody that is a celebrity advertising sneakers or advertising a certain dinner or a certain mortgage company, they have to be using that mortgage company. And of course, the problem that I have as an attorney is, what do you mean using it? Have it and then put it in the basement, or really use it in daily use or whatever, you know what I'm saying. So I have a problem with the word use. In your textbook, the FTC filed a claim against Silhouette Distributors, Inc., and it is owner, Mr. Claver, for making false and deceptive claims on a Spanish language television as it advertised that its product would eliminate cellulite. Very interesting. Please, what is the outcome of the case? Was the advertisement misleading? Who determines whether the action is misleading or not? And after you read in the case, who's determining that? Is it the FTC? Is it because they got phone calls from people after they have been tested the cream that the cellulite did not go away? What's going on here? And do you think that the fact that Silhouette ad appeared on Spanish language television influenced the outcome of the case? Because the Spanish people, that's ethnicity and national origin, they are protected under the law, and therefore here is the FTC. Is the law more protecting a member of a minority group than the prevailing culture people? In one of the cases that I wanted to share with you, which is decision was differently, I would like you to compare the Silhouette case with this case, because from the outcome from that case, you're going to see that this case had a different outcome. The Federal Trade Commission in this case was the staff of the Federal Trade Commission. Now remember now, all at once, this is a public agency. Their staff, their work, their people monitoring the advertisement went to court to stop a certain advertisement. And because they felt that there was not enough substantiated scientific control. So according to them, being that there was not enough, I guess, empirical data, scientific data, the advertisement was deceptive. The staff of FTC brought an action against Pfizer Inc. because the claims made by Pfizer in his advertisement for a sunburn treatment were allegedly unsupported by the direct studies on humans. And even that we have problem is how long ethically, can we make studies on humans, like especially sunburn? How long can you keep the sunburn lotion before you have blister or before you get skin cancer? So we have a problem even in the studies according to that. In this case, Pfizer argued that it had other forms of evidence sufficient to support its advertisement claims, that they had other alternatives, that they didn't need just the science to support the advertisement. The administrative law judge, now this is again administrative law, there is no jury there, nobody, who heard this adjudication, dismissed the complaint again against Pfizer, holding that no controlled scientific study should be required. Very interesting. The FTC then staff appealed this dismissal to the commission. And the FTC affirmed the administrative law judge decision and dismissed the complaint against Pfizer, ruling that the staff had not met its burden of proof in demonstrating that Pfizer advertising was insufficiently substantiated. So here we have the state staff as a plaintiff, and we have Pfizer as a defendant. And in this situation, the defendant, the court ruled for the defendant. The FTC noted that even though it was more rational and far less expensive to require a manufacturer to confirm its affirmative product claims rather than to impose a burden on each individual consumer to test the product personally, it was unclear as to whether the test used by Pfizer actually supported the claims made in its advertisement, because the product had not been tested on humans. So again, it's a very hard test to test the sunburn on humans. Although the FTC acknowledged that Pfizer had failed to demonstrate the existence of a reasonable basis for its product advertising, it admitted that the evidence was not sufficient to prove that Pfizer actually lacked a reasonable basis for its advertisement claims. There just was not enough evidence on humans that it was safe. The outcome of this case would seem to give the nod to manufacturers whose test results are either affirmative or inconclusive. So something for you to think about it, because if your tests are inconclusive, then it's not deceptive. Does this case permit advertisement then, so long as it cannot be conclusively disproven? So if the advertisement is not deceptive, if it's inconclusive, the test does not mean necessarily that we have hard evidence that they misrepresented society. Does it make sense to permit a manufacturer to rely on deduced test results or to assert that a product is fit for a particular purpose when it has not been tested for that purpose? Was the advertisement misleading then, according to your ethical view? Who determines whether the action is misleading or not? A court of law, the administrative law judge, the agency? Depends who files the complaint. Does the FTC Commission appears to have been swayed in part by the inability of its lawyers to conclusively disprove Pfizer claim? Was it lawyers now that failed to present a good case so that the FTC staff lost? Who filed the claim? Very important for you to look at and compare. Who is the plaintiff? Is it the state staff? Or is it a company, or what? Would the outcome of this case be different if Pfizer filed the claim? And I would like to hear that. Here's additional cases that I would like to share with you that will clarify a little bit in your mind what is a deceptive advertisement, especially for your student that someday will end up in marketing. In 2002, Amboy National Bank violated the disclosure requirements of the Truth in Saving Act, TISA, when it is ad and account disclosure for money market saving account. Very important, because all of you are going to go through this some way, somehow. The bank failed to calculate the annual percentage yield according to the method prescribed in TISA regulation, which require a bank to state the annual percentage yield a single composite rate computed on a year term. And then in 2002, another case, Think Achievement Corporation represented that if a person seeking employment by the United States Postal Service bought the material, it was a sure thing that they would score 95% or better on a postal service test. And you know this is going on for other professions too. The ad was fraudulent, even though the ad offered a money-back guarantee, because the defendant, Think Achievement Corporation, knew that many consumers would not bother to seek a refund of $46.95. And because some recipients of the materials excuse me, might have scored 95 or better on the test if they had never bought them. So, discussion. After reading this material in your textbook and also my notes, the additional cases, the lecture, and keeping in mind how the court's ruling will try to enforce what is appropriate behavior according to society at large and reflect the prevailing culture, you will be able to decide the following cases. Does advertisement then, or advertising, mold or reflect the values of our prevailing culture? I'm going to be posting this case on our discussion board. And it's a very interesting case because someone is paying to put an advertisement on a magazine. And the question is a magazine then liable? Assuming you're a judge in this case, reviewing this case, in whose favor should you rule and why? Thank you.